Hi guys, welcome to my channel. My name is Diana Romanovska, family law attorney practicing divorce, prenups, postnups in California, San Francisco. Today I would like to talk about the most common questions people ask. Question number 1, is California a fault state? No. In California, the reason for divorce does not matter anymore. For example, if someone cheated on the other spouse or was abusive or did anything wrong, quote, for the other spouse to consider wrong, that doesn't matter anymore for a long time already. When you fill out the form FL 100, which is a petition for divorce, there is a checkbox, grounds for divorce, and you will see the first ground is irreconcilable differences, which means we don't get along anymore. This is it. We're getting divorced. Nobody's gonna care about what the reason is. Now, it does matter if someone is committing domestic violence for custody issues and visitation issues and the safety of the children, but not for the reason of getting divorced. So if someone wants to get divorced and the other spouse says, no, I want to stay married, in California, the spouse number 1 who wants divorce will get the divorce regardless of the other spouse's opinion and wishes. Second most common topic people discuss is child custody and visitation. And child custody there are 2 types, legal and physical. Legal is who is making important decisions, which is typically joint. Both parents mutually make important decisions about education, health, religion, and other important decisions. And then there is a physical custody, which means where the child is primarily residing. And primary address could be, for example, with mother, so she can use that address to enroll into school with the other parent consent. And then we have visitation, which has nothing to do with legal and physical custody. So custody is one term. Visitation is important for obvious reason for visitation. And also, once we know how many days the other parent has visitation, then we create percentage, which will then we can go and calculate child support on the website. For example, child support services, if you type in Google, child support calculator California, and then you click advance on the top where it says percentage and calculate how many days, and then it will help to generate a percentage number, and then type in monthly income and fill out the form, click OK, and then it will generate child support. A third important topic is spousal support. I have a whole separate video about spousal support. Spousal support is given to the other spouse. It's not child support. It's alimony, but for the other spouse. And usually it is given to maintain the standard of living during the marriage, to help the other spouse in less financially privileged spouse during the divorce proceeding to maintain the standard of living so that the other spouse is able to finish the divorce. And then after divorce is finished, it's called permanent support. Permanent doesn't mean forever. Permanent means after divorce. In order for that spouse also to get on their feet and receive that support to maintain the standard of living. If the marriage is under 10 years, it's considered short-term marriage, where the length of spousal support is half of the length of the marriage. If the marriage is over 10 years, then support could be truly permanent until one spouse dies, remarries, or modification factor if the receiving spouse cohabitates with someone, romantic partner who financially supports them. So that's the general rule. There are so many exceptions. For example, it doesn't mean that the spouse who will be receiving support is going to be lazy and not do anything. If they have ability and capacity to work, the court could impose sick work order and impute income, which means even if that spouse doesn't work, because they're so lazy, therefore the income is going to be imputed to the level they could earn with help of vocational evaluator or at least minimum wage, depending on their education level. Then on the other side, if the other spouse doesn't want to pay support and voluntarily quits the job and says, I'm not going to pay you, I'm not going to pay anyone, lose-lose, then also the court can impute the other spouse's income to the level they used to earn. In 12 years of doing this, I never seen the court imputing other spouse income if they're not working. Usually people don't quit just not to pay the other spouse support, but there is a case law around that, so maybe one day someone did that and it became a case of appeal. Okay, child support. Child support, we use the online source is child support calculator. So if both parents earn the same amount of money and they have the same amount of visitation, most likely they're not going to have child support. Child support usually is designed for shelter and food for the child, for the parent who is caring for the child. So if I have 100% visitation of the child and the other parent earns as much, most likely they're going to owe me support because I need to, on top of my salary, I need to support that child's shelter and education. Everything else, out-of-pocket medical, is mandatory 50-50, meaning the other parent cannot just say, well, you didn't, I don't want to pay. They have to. Any other expenses such as extracurricular, other type of expenses can be split 50-50 in very rare circumstances proportionately to the income. So the first level of child support is basic child support, which is we use that calculator. Child support services calculator does not have bonus table. So if you do want to include bonus, include that as part of the salary, as other income, to calculate the total amount for the year or monthly throughout the year. Otherwise, you would need to contact a lawyer so that they can have a bonus table. Sometimes it's a two-way bonus table where if one person gets a bonus, they will have to pay a small percentage. I think it's up to 27%. Sometimes it's 10%. It depends on the income. So there will be a small percentage of bonus towards child support. Basic child support, then we have add-on. Add-on is mandatory out-of-pocket medical expenses, visitation expenses to travel to and from visitation, and childcare, which is designed for the other parent to work. So if the other parent is searching for work or is working, then that expense is split 50-50. Everything else is also 50-50, but based on their agreement. Domestic violence. Domestic violence is a very touchy subject. On one hand, Domestic Violence Prevention Act wants to protect victims of domestic violence, children from abuse. And abuse is defined broadly. It could be disturbance of peace since 2016, coercive control. So there are different terminology that include into domestic violence. Once the party who is a victim of domestic violence gets the restraining order, there is an automatic presumption of sole legal and physical custody for the child. On the one hand, okay, but on the other hand, misused for custody battles. And it gives sometimes a ticket to run away with children. So before filing domestic violence, it's important to assess the future, because the other parent won't be able to talk to that parent who has custody for a long time unless there's an exception for peaceful communication over app to discuss child-related topics. Could be supervised visitation, and then after that other parent, alleged abuser, completes 52 weeks of a batterer intervention program, which is usually what the court orders, they can come back after 1 year and rebut the presumption and say, I'm recovered and now I want 50-50. So domestic violence is helpful to get some peace of mind for some time. It could be 1 year, 3 years, could be longer. But even though the domestic violence is given for 3 or 5 years, the alleged abuser can come back and ask for joint legal custody and ask for more visitation after 1 year. So it doesn't really give permanent solution and peace from the other parent. And if the other parent violates domestic violence, the order, then the court can extend it for permanent. Finally, prenuptial and postnuptial agreements. Prenuptial agreements are usually done before marriage. Postnuptial agreements and marital settlement agreements are done postnuptial after people marry, and marital settlement agreements are done when people are going through divorce. So for prenuptial agreement, it's very highly regulated. I suggest to have 2 lawyers, one drafting, one reviewing. Otherwise, the prenup could be completely unenforceable, especially the spousal support provision. Full disclosure is required. 7 days before signing, the prenup should not be touched. I'm going to slow down here. You know, when you drive fast and then there is a very important moment on the corner, this is it. The 7th day is that moment where you negotiate, start negotiation at least a month before. You negotiated everything else and then stop and do not touch the prenup with any significant changes for 7 days, and then sign and then marry. It could be sign and marry same day, but 7 days, no significant changes can be made. It's regulated in Code Section 1615 Family Code, California. Very important. Full disclosure, 2 lawyers, 7 days. And of course, it has to be voluntarily signed, no coercion. And then there is also a clause at the end of this code section that says the court has the discretion to set aside a prenup if it's unconscionable, meaning if it's so unfair that enforcing it would not make sense. So these are the topics that are hot in discussion in 2023. If you have any questions, please comment down in the section down below. Like the video, subscribe, and I'll see you soon. Bye!